Hürmetlik hanımlar, efendiler, Halkara Uyghur Minberi parlament a'zolari uchrashishi boshlandi.
ご来場の皆様、ただいまより国際ウイグルフォーラム各国国会議員間の国際会議を始めます。
Ladies and gentlemen, the session at the International Uyghur Forum Global Parliamentarian Convention is now starting.
The star panelists, and I'm the first time moderating, so help me God. The topic is the avenues towards legal action, mapping foreign influence, blocking accountability on human rights atrocities, and it is partly or importantly a legal discussion we are going to have. Briefly, the number of legal initiatives have already been undertaken, and court filings already submitted in a number of countries, including Canada, UK, and in Argentina by using the universal jurisdiction. And the 2 days ago, and Uyghur Rights Advocacy Project and Human Rights Action Group, we prepared the one request letter to the Canadian government, requesting them that Canada should register a diplomatic communication against the government of Egypt and the Kyrgyzstan for breaches of Genocide Convention and the Convention Against Torture. And as we know that ICJ, the principal organ of jurisdiction or organ of United Nations, and they handle disputes between states. And China is a member of the party to Genocide Convention, but China has a reservation over the ICJ jurisdiction. But the other countries who are deporting Uyghurs back to China, just like Kyrgyzstan, Egypt, and a number of other countries, they do not have that reservation. And for that reason, in July 2023, we have a legal discussion in Alma, Quebec, with the participation of 7 legal experts, including Michael Pollack. And we discussed nearly 46 legal items and how we can escalate the Uyghur genocide into the international available venues, and also how we can effectively address the Uyghur forced labor through legal means. So this is going to be our main topic, and we have fantastic panelists with us today who are going to help to understand better what we can do and how we can address the atrocities being committed against Uyghurs by the Chinese government through legal means. So let me go with our dear friend and the first U.S.-trained lawyer and U.S. International Religious Freedom Commissioner and former chair of the commission, Nuri Turkel. And let me introduce one by one when the turn comes. So let's start with the Nuri. And the Nuri Turkel has involved in a number of legal initiatives in the United States, and a number of bills already passed, and he contributed a lot. And he's at the same time lawyer. And so, Nuri, if you can just give us the understanding where we are at right now in terms of using the legal means to address the Uyghur genocide and what we can do better.
Thank you very much. I'm glad to be part of this discussion. I'm sorry in advance. I wanted to apologize that I have to leave before the end of the panel discussion for a meeting that I need to participate outside of this building. So let me when we talk about China's malign activities and their successful avoidance from consequence, legal, economic, and other areas, it's important to see what they doing and why they doing and how they avoiding responsibilities. So I'd like to make a few points to set the stage for this discussion. That includes China's technological ambition to become a primary a leader in various technological fields. This is relevant because Chinese tech firms have a presence all around the world, including the United States. Going after the government through legal channels are challenging, but there is a possibility that with a coordinated, well-planned, and well-executed plans, Chinese companies can be held to account. The other area is China's economic and diplomatic coercion, forcing some countries to help them avoid responsibility. As Mehmet pointed out, there are 153 state parties to the Genocide Convention. Only 10 of those state parties, some governments and parliaments have taken a position and fulfilled the treaty obligation. Before delving into these two specific areas, let me share my perspective as to why Xi Jinping's China does the things that we have been seeing, witnessing in the backdrop of facing backlash and pushback on global stage. First of all, Xi Jinping does not believe or see all of China's success over the past 20 plus years as a result of CCP's integration into the international system. He would argue that it was a result of CCP's policies, resilience, and industriousness of the Chinese people. So he reads the actual facts very differently. This is something that the various governments around the world, at least from what we see publicly, not being fully appreciative of. Second, Xi Jinping's China himself, specifically if you read his speeches, going back to 2013, number 9 document, China's national security strategy published in 2014, looks back on history to a time when China was the center of the world. At the outset of his leadership, he stated China's great ambition to reclaim China's centrality in the global stage. So to bring that back, China needs a different international order. China would not be at the center of the world if its values and the way that they trade, the way that they conduct themselves in international multilateral settings, or the investors not playing by their rule that prevents China to become or return to the center of the world. This has been displayed through two things. One, China's ambition for tech supremacy. This is important when you have some background knowledge, it will be easier to identify the issues. For example, China's key objectives in the technological ambition, one is self-reliance. Since the Trump administration's decision to go after the Chinese tech firms with the sanctions and entity list designation, the Chinese leadership feel the pain that their access to foreign markets, extracting foreign technology and resources have been hampered. China attempts to dictate terms of economically, geopolitically by dominating the production of linchpin technologies and resources. This is where they're utilizing the American investors and American tech firms specifically in the Silicon Valley to achieve that objective. China is also gearing up to wield economic coercion and massive scale by becoming the supplier of vital products and services. That includes renewable technology, specifically solar panels and the EV batteries. And if you listen to Xi Jinping's own words, former Deputy National Security Advisor Matt Pottinger often says, you don't have to listen to the activists, you don't have to listen to the policy, or you don't have to listen to me, just pay attention to what Xi Jinping himself says. For example, here, Xi Jinping said China must successfully fight tough battles for the key core technologies, and China must enhance its superiority across the entire production chain. Back in 2020, the Trump administration identified 80 critical supplies that the United States and our democratic allies have been relying on, including the PPEs, the ventilators that resulted in many deaths in the United States. China is now, as you know, a leader in the telecommunications sector. And it literally, while this has been in process, the international community sadly was asleep at switch. And the Chinese also have been very effective in building their own choke point technology because of this restrictions being imposed by the United States and our allies. But there's a good news that the China imports 70 to 80% of its oil, computer chips, advanced medical devices, and 90% of it advanced manufacturing equipment. This is where the area that we can hold them or push back. And also, we have to remember the R&D spending, the Chinese investment in specifically in the emerging technology, AI space, quantum computing, semiconductors, and advanced robotics, and synthetic biology has been on the rise. And also, this is also something that is very relevant to the Uyghur genocide, the collection of data. China has become world's most powerful data broker by walling China's data off from the world while buying and stealing other countries' data. So without this data, they will not be able to advance its AI. As you know, when they start rounding up Uyghurs, the Chinese police rely on an AI algorithm to issue arrest warrant. In my book, in the beginning of my book, I profiled a European Uyghur who was part of that 17,000 people rounded up in 10 days in 2017. So the Chinese have an ambition to become a leader in AI by 2030. Just to give you, put this in perspective, 75 countries in the world today use AI. Of that, 60 are linked to the Chinese technology. And 50 of them are using Huawei technology. This is one company that we need to go after. And also, telecommunications sector, the Chinese technology firms, including the ZTE, the Huawei, Hikvision, SenseTime, iFlyTech, all of them have been so effective. Today, China is the world's largest telecommunication provider. They have installed fiber optic cables, submarine cables. 90% of the world's data are transferred through the Chinese submarine cables installed. Once those telecommunication towers are up on the mountain and on the ground, or once those cables are installed, you're locked in. And this is something that cannot be replaced. It's extremely expensive to do that. And also, companies like Huawei claim to have a cloud computing contract with 140 countries. We have about 190 plus countries at the United Nations. Think about 140 of them already using. Another company, Hongtong Group, has installed 15% of world's fiber optics. And also, the China is also doing something else. They setting international technical standards. They have a saying specifically and publicly that goes along the lines of third-tier companies make products, second-tier companies make technology, and top-tier companies set standards. So the Chinese are marching to set the standards by 2035. So eventually, all the tech firms in the United States and Europe have to follow their own, the Chinese standards. The other issue, the long-term economic dependency. This is where we also need to identify big companies, specifically the ones named in the or been implicated in ongoing slave labor practices, and push for a legal action in addition to the administrative proceedings that have been kind of halfway enforced. This is specifically important for our European allies who have experienced hardship since Russia's invasion of Ukraine, specifically in the energy sector. It must be clear that what they experience in energy field, energy dependency in Russia would be a cakewalk compared to long-term economic dependency on China. So the companies that have been implicated, as somebody who's in the corporate law practice, I can say this, that most companies don't have a due diligence, business human rights due diligence practices put in place. Some of them do it, and they mention that in their annual report, but for the most part, they have been finding a way to avoid responsibilities. So in summary, I would recommend, us changing the strategy. Naming, shaming did not really bring the type of result that we wanted to see. If you look back, Nathan Russer's initial report for ASPE named 83 global brands. They're still practicing, still doing business in communist China. So I think we need to change the strategy and focusing on advocating for strong legislative regulatory measures. So when you talk to the business leaders, they often say, look, it's not illegal for us to do business in China. If you want us to follow new laws, put them out. At the same time, they lobby against that kind of legislative initiatives. So we need to advocate for legislation in Canada, UK, and the United States. There are momentum in the United States Congress, specifically under the leadership of the chairman and ranking member at the CCP Select Committee in Washington. And then going back to the earlier point, we have to identify several companies, Hikvision, for example, one of them, and the other companies, and look for venues in the United States, in the district court, to file complaints against them. Huawei has a big business presence in Plano, Texas, and other companies, TikTok, the parent of the ByteDance is the parent of TikTok, has a business presence in Los Angeles, and it's not that difficult. We have victims in the United States that they can come together. It just becomes, and then the next question is which law firm is going to do it? The big mega firms will not touch anything like this because their interest, their client interest, is paramount for them. And somebody who spent years in the corporate law firms, I know for a fact that they will not touch it. But if you can, with Michael and others, identify smaller firms, law firms that are specialized in areas like this, would be a good start.
Thank you, Nori, for eye-opening presentation. And it is really important that we start to talk about these tech companies. And I remember that last year, and we successfully pushed the government of Canada to cancel one contract offered to Hytera to keep the safe communication in the Canadian government, between government agency. And just one note that when the Canadian government offered that contract to Chinese tech company Hytera, that company was already being investigated in the United States, and there are 23 espionage charges against that company. And even Canada just failed to use the publicly available information just to block that company to access the government communication system. For that reason, it is really important, and thank you for that. And let me turn to Dr. Evelina Ochap. I'm sorry if I mispronounce your name. And she's a really well-respected international human rights lawyer and International Bar Association Human Rights Institute. And her main campaign and advocacy work is focused on the genocide-related legal work. And so she's our asset as a panelist, just to shed a light on the Uyghur genocide and what kind of venues that the Uyghur communities can take this issue to other level, next level.
Thank you very much. It's a great honor to be here with such wonderful panelists. And of course, the case of the Uyghur genocide is not the only case that I'm working on. I have been working on atrocity crimes, starting with the Yazidi genocide back in 2015. But as we were observing the different responses, we've seen a little bit more proactive responses in relation to other atrocities, which is, of course, a great shame. And indeed, I'm currently working also on legal avenues for justice and accountability in the case of Ukraine, and preparing a mapping exercise, identifying all legal steps taken to date within the last 1.5 years. And for each legal action, I have only a couple of paragraphs, and the document is already 44 pages long. And we've seen incredible responses, not only in Ukraine, we've seen incredible responses from at least 18 countries opening domestic investigations into the atrocities. We've seen incredible responses and engagement of the International Court of Justice, International Criminal Court. We've seen, of course, the establishment of a mechanism to collect some of the evidence of the atrocities by the Human Rights Council. So this is the way how to respond to atrocity crimes, but it never happened before, and most likely it will never happen again. So this is the only case in recent years of wonderful legal responses that we've seen, and this is something to pursue in the future, but again, very unlikely it's going to happen. And as we talk about legal avenues for justice and accountability, I would like to start with the issue of documenting atrocities. And in the case of Uyghur genocide, we've seen many civil society organizations documenting the atrocities, doing very important work. But unfortunately, until now, there have been no UN mechanism that would collect and preserve the evidence of the atrocities. Of course, we've seen such mechanisms being established, for example, for Syria, the so-called IIIM, for Myanmar, the so-called IIM, for the Daesh atrocities in Iraq, so-called UNITAD. And those mechanisms are doing important work that no one else can replicate it at this stage, I believe. And for example, in the case of UNITAD, the evidence that they collected, they've been using for domestic prosecutions around the world. And currently 14 prosecutors in 14 different countries are using their evidence to ensure justice and accountability. In relation to the evidence of IIIM, this evidence is being used in 12 different countries to ensure justice and accountability. So these are mechanisms that we should try to replicate also in the case of Uyghur genocide. And some time ago, I drafted a proposal for a UN General Assembly resolution to establish also a similar mechanism for the atrocities against Uyghurs. But unfortunately, at the time, I believe it must have been around 2 years ago, there was no interest in this kind of proposal, especially as the Office of the High Commissioner for Human Rights was already looking into the situation of Uyghurs in Xinjiang, was to some extent collecting some information, was planning also to go to Xinjiang to see for herself the situation in the region. And of course, later on, she published a report that found various crimes, including possible crimes against humanity. But there have been no follow-up from there. And there was an attempt, of course, at the UN Human Rights Council to ensure that the Human Rights Council has some time to look into this report, consider the evidence collected, consider the findings of the High Commissioner. But unfortunately, this step was voted down. And among the countries that voted against this proposal was Eritrea, which is also accused of committing atrocity crimes, including in the Tigray region of Ethiopia. Sudan, and we know exactly that, again, atrocity crimes are happening in Sudan at the moment, including possible another genocide in Darfur, 20 years after the last genocide. And Cameroon, also accused of international crimes. So these were the bodies of China that supported the efforts to ensure that there is no time given to discuss this important report and the findings from the, so to some extent, an inquiry done by the High Commissioner for Human Rights. And right now, of course, I think it is still important to try to pursue and try to table a resolution that will establish a mechanism to collect and preserve the evidence of the atrocities. But unfortunately, as we see around the world, there are steps to move away from such mechanisms. Just a few weeks ago, we learned that Iraq requested to close UNITAT, the very mechanism that collects the evidence of the atrocities against the Yazidis, saying that we don't need this kind of external mechanism, and they want the mechanism to be closed after September 2024. A few months ago, also Ethiopia said that they don't need a mechanism, or they don't need a commission of experts looking into the situation in Ethiopia, and there was no resolution tabled at the Human Rights Council to extend the mandate of this important mechanism. So, of course, if such a resolution was to be tabled, it is very likely that of course, China would want this resolution to fail. And when we talk about resolutions before the General Assembly, we're talking about the need to establish a majority. We need to secure a majority for such a resolution to pass. And then, of course, the question is who would support it and who would be thinking more about their interests, the support that China provides them with one way or another. In any event, I would still encourage to look into this kind of proposal and table it as a matter of principle, even knowing that it may be very difficult to secure the majority to ensure that this resolution passes. And then, of course, there are other UN mechanisms that need to be engaged in what is happening in China, and one of them is the UPR, Universal Periodic Review. And China is going to be reviewed by the UPR next year. And in preparation for the review, on behalf of the International Bar Association and the Coalition for Genocide Response, I made a submission which covered the issue of the genocide against the Uyghurs, and also a small section on national security laws. And as we prepare for the upcoming UPR review, it is crucial to engage states and make sure that if we have any kind of recommendations for states, those recommendations should be transmitted to them as soon as possible. Because ultimately, during the UPR review, states will be able to make recommendations to China. Whether China is going to accept them, reject them, or note them, that's a different matter. But again, as a matter of principle, there have to be recommendations in relation to the issue of genocide and supporting victims and survivors and so on. And later on we'll hear also with the former Special Rapporteur on minority issues. And the Forum on Minority Issues is a great platform, again, to engage and to provide information and evidence of the atrocities. And I've been involved in a number of the forum sessions in the past. And whenever, of course, any allegations are made against China, Chinese representatives would normally stand up and try to challenge the information. Another amazing platform to engage is also the Human Rights Council. And I believe it was last year, I organized a side event on the situation of religious minorities, and Rahima Mahmoud spoke at that session. And I remember after she spoke, the Chinese representative requested the floor, and he started saying that actually Dolkun is our lovely Dolkun is a terrorist, and of course Rahima, by working with him, she's also involved one way or another. But in any event, despite those challenges at the UN, it is crucial to continue being involved there. And I think I won't be mentioning much about the International Criminal Court. As we know, of course, the International Criminal Court doesn't have the territorial jurisdiction of the situation in China, unlikely that China would ever become a member, and also unlikely that the UN Security Council would refer the situation in China to the ICC. Even if there was such an attempt, China could easily block it with a veto. In an event, also as a matter of principle, if I was US, UK, I would still try to table such a resolution. Again, as a matter of principle, the chances of it succeeding are zero, but nonetheless, it is crucial to pursue such steps and to make a clear statement that we cannot stand by as horrific atrocities are being perpetrated. And I would like to briefly focus on domestic prosecutions, and indeed under the principle of universal jurisdiction. And I know that Michael will cover the case of Argentina, which is an important one, and we've seen very important cases also in relation to the Rohingya genocide. but I will skip Argentina. But I wanted to comment very briefly on the UK, because in the UK, especially such crimes as genocide and crimes against humanity are criminalized in the International Criminal Court Act from 2001. And this act also includes information on, or provisions on universal jurisdiction. Unfortunately, under Section 51 of that act, the universal jurisdiction is very narrowly defined, to the point that it's more extraterritorial jurisdiction rather than universal jurisdiction. And under Section 51, UK courts could prosecute genocide and crimes against humanity perpetrated in another country, but as long as the perpetrator is a UK citizen or UK resident. So of course that limits the options. And unfortunately also, as a reality check, even in the case of the Yazidi genocide, where we are talking about 400 British Daesh fighters who returned back to the UK, there have been no prosecution for genocide and only 32 convictions for terror-related offenses. So that's the reality check. We have the law that, at least for the Yazidi, for the Daesh perpetrators against the Yazidis, we could see some prosecutions under the principle of universal jurisdiction, but we have seen zero of such cases. And one country that I believe that there is also a possibility to engage is actually Germany. And Germany has been a key country, for example, engaging on the Daesh atrocities against the Yazidis, secured 3 convictions for genocide, 5 convictions for crimes against humanity, and there are several other cases ongoing. And the law on the principle of universal jurisdiction in Germany is much, much broader than, for example, in the UK. And it's so-called absolute universal jurisdiction. So the courts in Germany can prosecute anyone, no matter where the atrocities are being perpetrated and no matter the nationality or residence status of the perpetrator. And indeed, that's what was the key in the case of the Yazidi genocide as well. But before anything like that can happen, it is key for the prosecutor to actually open structural investigations. And again, in order for this to happen, it is crucial to collect the evidence and ensure that the prosecutor is also in possession of all this key evidence of the horrific atrocities perpetrated against the Uyghurs. And last but not least, I wanted to mention some of current initiatives, current and also past initiatives, legislative initiatives in the UK. And one of them was the genocide amendment to the trade bill back in 2021. And this amendment to the trade bill was to introduce a new mechanism in the UK to ensure that courts could consider evidence of such atrocities as genocide and make a formal determination of the atrocities as genocide. And this is because the UK government's position is that it is not for politicians to make such determination of genocide, it is for courts. And this proposal, it was initially tabled by Lord Alton of Liverpool and then supported by politicians from all parties. And indeed, whenever this amendment was brought before the House of Lords, it was winning. It was only in the House of Commons that it was losing again and again, but every time Lord Alton would bring back a slightly amended version of this amendment. Unfortunately, at the end of the day, the government tabled wrecking amendments with a very different message to say that if one of the relevant committees of either of the House establishes that genocide is being perpetrated, then the Secretary of State would have to follow this determination and with responses. And only if the responses are not adequate, that's when there would be a debate in either of the houses to discuss the evidence, to discuss the UK government's responses. So this amendment didn't do much, but nonetheless, it received the support from both houses and became law. And currently, it's the Section 3 of the Trade Act 2021. And it's a very narrow provision, meaning that most likely we'll never be able to use it. The only case where we could use it right now is, for example, India, but no one wants to touch India and the situation of religious minorities there. But that's the only case where this amendment could, section 3 could potentially be used. But nonetheless, despite the fact that the original Genocide Determination Amendment failed, Lord Alton will be bringing back the very message of this amendment with his new private members bill, and it's going to be tabled in the next few weeks, just after the King's speech, which is happening on the 7th of November. And this bill is, again, to introduce a mechanism that will enable courts to hear from victims. It will empower victims to ensure that they can seek truth about the human rights abuses they suffered. So this amendment is very much victim-centric in its approach, and something that we are missing in the approaches to genocide across so many countries. Unfortunately, bad news again, this is a private members bill, and will have only 1 year before the next election. So it means that unlikely it will receive enough time to go through the whole process and become law. So it will send a message, it will provide us with an opportunity to engage in important debates about the situation of Uyghurs, about the situation of other communities, and how this bill could empower them. But unless government actually approves of this bill and wants to make it a government bill, the chances of it becoming law are, again, very, very, very small. So I'm sorry I'm not leaving you with more positive messages. Some recommendations in terms of proceed with all those steps before the Human Rights Council, before the UN General Assembly. UN Security, Human Rights Council and Security Council General Assembly, no matter what's going to happen there, as a matter of principle, to send those important messages to China and to anyone else who is supporting China, that only because the chances are low at this stage, it doesn't mean that we should stop. So I will stop here, and thank you very much.
Thank you. Thank you, Evelina, for this education, and we learned a lot. And also, I would like to thank you for your future and our. Okay. And when we submit the legal application in Canadian court, just asking federal judges to issue a declaratory relief on Uyghur genocide. And you covered that story on Forbes. It was a good encouragement. And also, we had first the Uyghur Legal Summit this July, and we would like to see you next year. We are going to continue to brainstorm about the legal venues, and your expertise and your valuable contributions always welcome. And let's move to next, our panelist, Mr. Shadow Senator, Mr. Paul Strauss. And probably you have more to say because you are coming from the capital of the world, Washington, D.C. We would like to hear your perspective as well. Thank you.
Thank you very much. It really is a privilege to be here to help explain the position I hold. It's somewhat unique. I represent the people of Washington, D.C., which is the capital of the United States, but it is not one of the 50 states. And so I came to this movement when we joined the Unrepresented Nations and Peoples Organization, because the United States treats the capital and some other parts with a differential political status. And normally when I travel around as part of these international conferences, I am being critical of my own government for violating what we contend are our political rights. And I often talk about how in the enforcement of international law and the principle of equal accountability, you must prosecute the misdemeanors as well as the felonies. But today, I come here as a proud American in unity with my country's policy and our leadership on this important issue to call attention to one of the great felonies and certainly horrific abuses of international law. 2 years ago, my Secretary of State determined that since at least March of 2017, the People's Republic of China, under the direction and control of the Chinese Communist Party, had committed crimes against humanity against the predominantly Muslim Uyghurs and other members of ethnic and religious minority groups in East Turkestan. He didn't use the words East Turkestan, but I will. The Secretary of State further determined that the PRC, under the direction and control of the CCP, has committed crimes against humanities in this group, and stated his belief that this genocide is ongoing and that we are witnessing the systematic attempt to destroy the Uyghurs by the Chinese Party state. I don't often concur with everything my government says, particularly with the policies of Donald Trump's administration, but in this case, I fully concur with the position that they've taken. And I'm heartened that so many other governments have joined the U.S. government in describing what's been taking place in East Turkestan as genocide. Exhaustive documentation and evidence substantiates these claims as serious abuses of human rights. And of course, as we know, the PRC is very difficult to hold to account for its transgressions under the conventions of international law. I was disappointed in 2020 when the ICC decided not to investigate these allegations based on jurisdiction, but the other lawyers have spoken about that in greater detail. So I'll move on to talk about what the Human Rights Council could, in theory, do to establish international fact-finding missions and commissions of inquiry to investigate the allegations of human rights violations and genocide and make recommendations for accountability and reparations. They've certainly done that in other cases, such as Myanmar, Syria, and North Korea. But of course, that requires the support of a majority of council members, which has been difficult to obtain given PRC's significant diplomatic influence and, more significantly, perhaps their economic leverage. Unfortunately, the PRC claims sovereign immunity from lawsuits filed by victims or states in foreign courts. And in the United States, the Foreign Sovereign Immunities Acts of 1976 grants them blanket immunity in most U.S.-tried lawsuits. The PRC, of course, refuses to cooperate with human rights mechanisms such as the Office of the High Commissioner for Human Rights, which issued an extremely damning report last year. That report credibly found that the PRC's abuses in East Turkestan constitute crimes against humanity. And since that bombshell report was released, Beijing has demonstrated little change in the trajectory of its policies towards the Uyghurs. Uyghurs abroad continue to have no contact with their family members. Many don't know, as we've heard so many times over the course of this conference, if their loved ones are taken into custody or forcibly disappeared or still alive. So given these unfortunate realities, what can we do to hold the PRC to account for its reprehensible behavior? Clearly, what's required is concerted and coordinated action by the international community, as well as political will and moral courage by individual states that respect human dignity and the human rights of all. There's a pressing need for the concerned governments to take determined actions to advance accountability given the gravity of these abuses. I believe governments around the world should work towards the successful adoption of a UN resolution to set up an investigative mechanism with the mandate to investigate these allegations. But as we've heard today, the data is there. We know what these investigations will show. Governments must pursue criminal cases under the concept of universal jurisdiction, this legal doctrine that allows national courts to try cases of serious international crimes, such as genocide, crimes against humanity, war crimes, torture, and enforced disappearances, wherever they occur. The High Commissioner of Human Rights, Volker Turk, should update the Human Rights Council on the situation, following on the recommendations of his own 2022 report and present an action plan. It would be fully appropriate for him to spearhead an initiative, possibly jointly with special procedures that mandate holders such as the Working Group on Enforced and Involuntary Disagreements with governments of the Uyghur diaspora populations to help these victims and families trace these missing persons. Yes, considerable information has been gathered, much of which is publicly available, but there has been no high-level coordinated initiative specifically focused and pressing for the release of those arbitrarily detained in East Turkestan. this initiative should be launched without delay. And governments must explore the use of this principle of extraterritoriality to hold Chinese corporations accountable for their complicity in crimes against the Uyghurs in foreign courts. It is a legal doctrine that allows national courts to apply their laws to activity outside their borders, but that when those activities have an impact within the borders. And Nouri, of course, talked about the ability to hold businesses accountable where we can't necessarily do it with the states. That's one of the great things. Normally when you're on a panel with 4 lawyers, you're going to get 5 or 6 different opinions, but it is nice to have a unity of goals and ideas here. Governments can continue to provide financial assistance to media and civil society groups in emerging economies to encourage them to focus on their abuses in East Turkestan and prompt public pressures for their leaders to change their positions. Public awareness about what is happening can also serve as an antidote and a bulwark against other governments copying the PRC's approach. We can't let current events and other conflicts around the world divert attention from the atrocities taking place in East Turkestan, but we can raise our voices and keep the plight of the Uyghur people in the forefront of this agenda. Experience has shown that the PRC at least tries to value its international representation, and we have to continue to shine the light on what's happening in East Turkestan. And I knew coming here today would be very deep and personal for me because as an American, I'm often proud to come from a country which is able to use examples of its power to stand for freedom. But we can't really intervene militarily despite how critical this situation is. And what the United States can't do with examples of its power, we can attempt to do with the power of our example. My family came to the United States in 1917, fleeing what was then called a pogrom, and later the rest of my family, who did not leave what's now Belarus, perished in the Holocaust in the years from 1941 to 1944. I know that one of the reasons why I'm able to do the work I do is because my family was able to escape and come to a country where the freedom of my religion is guaranteed, and where the freedom even to come to conferences like this and hold my government to account for the differential political treatment of my constituency in the District of Columbia values my freedom and respects that opportunity. I've been so moved by the examples that I've heard today. And it means so much to me to be able to, as a descendant of genocide victims, stand in solidarity with you here today. I pledge to you that I will do all within my power to continue to shine the world's attention on what is happening here. I thank you for this wonderful opportunity. I particularly want to thank Dolka and Isa for all of the work that the World Uyghur Conference has done. I was asked by a journalist before I came into this conference what we're going to do in the United States to advance this cause. The World Uyghur Conference and the Uyghur movement is led by Uyghurs. We're going to wait for you to tell us what you need for us. But we appreciate the opportunity to stand in solidarity with you, and I thank you all for your kind attention today.
Thank you, Paul. Thank you for your solidarity and your support and sympathy. It's very much appreciated. And we have a very active community in Washington, D.C., and you will find a lot of your friends there to add your voice. And let's move to next. Just we met a number of times each year with Michael Pollack, and he is our, I can say, legal counsel, and he represented us in a number of legal initiatives, and he was at the ALMA, the Uyghur Legal Summit as well, and he shared his valuable experience. And so, yeah, there are a lot of things that Michael can share with us. Please have the floor.
Good afternoon, everyone. Good afternoon, everyone. I think that's a bit louder. There are a number of things which came out of the Canada Summit, legal summit we had this year, which was fantastic. Some of them we can't share with you, that are really big moves, but others we can go over. Just before I get started on my presentation, I thought I'd respond to some of the points made by my fellow panelists. We had a point made in relation to the difficulties with universal jurisdiction in the United Kingdom by Dr. Ochab, and she's absolutely right. The British law has been restricted in relation to universal jurisdiction, unfortunately, and we've seen this kind of move in a few other European countries as well. But there is one area in relation to torture of courts where we have a more pure universal jurisdiction in the United Kingdom. We, of course, require the person to be within the jurisdiction, but it doesn't matter where the torture is committed. So we commenced proceedings when we heard that the governor of Xinjiang region was due to come to the United Kingdom on an unofficial visit, and he changed his mind about coming in the end. But there still are opportunities there for those types of offences. I work as a barrister, but I'm also chair of Lawyers for Uyghur Rights, and we look at all different legal strategies, and there's nothing which is too far-fetched. So if you have any legal ideas, you say, well, why aren't you doing this or why aren't you doing that, please come and have a chat to us about it. We're always happy to have a think about it. For example, in the United Kingdom, we were so very close to signing a deal with Huawei to provide our 5G network, which would have allowed access across the United Kingdom, including into our hospitals, military installations, etc. And we started litigation in relation to that. In the end, the decision was taken at the very last moment by the British government, I think because the Americans decided they didn't want to share intelligence with us if we allowed Huawei in. So it wasn't made on human rights and slavery grounds as it should have been, but on the security grounds, but at the very last moment there. So those are a few points in response. I hear what Nuri said about going after the companies, and this is something we're having a look at in the United Kingdom context at the moment, about the registration of companies. If companies are involved in slavery, and there's clear evidence of that, are they proper people to be registered as a company, either as a private company or as a listed company? And this is something that I think we can look at across our jurisdictions, really attacking those companies and saying, well, if you're going to behave in this manner, you're not a fit company to be registered either publicly or privately. So another area we looked at is looking for jurisdiction in relation to a criminal complaint. And this project I took on for the World Uyghur Congress and the Uyghur Human Rights Project, and it builds on all the work that has been done before. Most of you will probably know about the Uyghur Tribunal in London, which collected fantastic amounts of evidence, which we rely on in the work we're doing in Argentina, as well as the Essex Court Chambers legal opinion. And you would have seen that lots of the barristers and the Chambers itself was subject to sanctions because of that opinion. That really started the ball rolling in relation to the law and what was going on to the Uyghur people. The international criminal law has developed a lot since the first tribunals. So we had the Nuremberg trials, and then we had the tribunals formed by the Security Council, the International Court for the former Yugoslavia, the International Court for Rwanda as well, were Security Council tribunals. There's also been General Assembly tribunals, such as the Special Court for Sierra Leone. And that's something to remember. If you can get a majority of the General Assembly, you can set up a tribunal that way, which gets around the veto in the Security Council, China's veto in the Security Council. So that's something to have a think about as well. The international criminal law then moved on to hybrid courts. So we had the Khmer Rouge Tribunal in Cambodia, which was formed under Cambodian law with international judges. The Kosovo Tribunal, which is running at the moment under Kosovan law with international participation as well. But the problem with the establishment of these courts is you need overwhelming international political support. And unfortunately, we've seen China use economic power to restrict that support. So the Uyghur people have had to look outside of these courts for alternative means of seeking justice, and one way of doing so is through universal jurisdiction. As I spoke about, the Uyghur Tribunal was a really good base for doing this. But taking this one step further, we looked at Argentina as a jurisdiction for universal jurisdiction because it's the most permissive, the most liberal universal jurisdiction country in the world. It doesn't require any link in relation to nationality. You don't need the perpetrator to be in the jurisdiction to bring a case, which is why it's so attractive. Argentina, of course, has a long history in relation to international criminal law. Eichmann, of course, was picked up from Argentina, and they had their own criminal trials in relation to their own military, in relation to the disappearances there in the 70s and the 80s. They've had cases in relation to the Franco regime, where there are Argentinian victims as well. And quite recently, they've got an ongoing investigation for the Rohingya people, as well as a case more recently opened in relation to the Venezuelan regime there. But before I go on to talk specifically about the Argentinian case, we should look at universal jurisdiction across different countries. Dr. Okchab, she spoke about places like Germany, Switzerland, Belgium, where they have more and more cases coming through against members of the Syrian, Libyan regimes as well. One story which gives some hope about universal jurisdiction and about people's tribunals, such as the Uyghur Tribunal, is the case in Sweden of Hamid Nouri, who was a part of the repression of the student protests in 1988 in Iran. And some of you may know the story, but they went through Iranian prisons and just executed summarily student protesters there. In Sweden, they held a people's tribunal, very similar to the Uyghur Tribunal. They also had a report by an eminent British King's Council looking into what had happened there. So they collected all this evidence, and they held it for years. But then they found out that he was going to travel through Sweden, so they picked him up and they put him on trial, and he's been sentenced to life imprisonment there. So it really shows how all these little steps you take, from the establishment of the Uyghur Tribunal to the Essex Court opinion, to all the work that everyone in this room is doing, collecting evidence, it all builds up and adds up to something in the end, something which is very forceful and something which is very powerful. And not one person can do all of it. It comes from a collection of evidence, the political will, people making these arguments, and the establishment of people's tribunals. So it's all these different things put together, which creates the movement towards justice. In relation to Argentina's jurisdiction, under Article 118 of the Constitution, it says that crimes should be tried in the area where they take place, but when the crime is committed outside the borders of the nation, in violation of international norms, Congress shall determine by a special law the place where the trial is to be held. So for international crimes in Argentina, they can be held in any court in Argentina. They don't have to be held in Buenos Aires. They could be held anywhere across the country. I mentioned the Rohingya case, which is ongoing, the investigations in the Venezuelan case, the cases in relation to the Franco regime as well. It's a pure universal jurisdiction as opposed to limited, so you don't need any link to Argentina. It's judicial rather than political. And what I mean by that is in some universal jurisdiction countries, including the United Kingdom, Turkey and places like that, there is a political step. So you need permission of the Attorney General or the Minister of Justice. In Turkey, you need the Minister of Justice. In the United Kingdom, for many of our universal jurisdiction laws, you need the Attorney General's permission before you even get going with a case. So that's why Argentina is a attractive jurisdiction for the case. It also has, because it's a civil law jurisdiction rather than a common law jurisdiction, it has a long investigation period where a judge and a prosecutor can investigate the case and can call witnesses to give evidence during that period without the defendant having to be in the country at that point, which is attractive because it may allow for the Uyghurs for the first time to give their evidence on oath before a judge in a court, which I think would be a very powerful moment in the journey towards justice. We've submitted the criminal complaint to the courts there. It goes before a prosecutor and a judge at the prosecution stage. If they open an investigation, it goes to the investigation stage, and then this is where they start hearing evidence from experts, from witnesses of facts that we've heard over the last couple of days. So very powerful evidence, both expert evidence and witnesses of fact as well. So at the investigation stage, this evidence will be put before the court, and at the end of that stage, the judge makes a decision in relation to the next steps of the investigation. The crimes we're looking at, of course, are genocide in relation to preventing births within the group and forceful transfer of children. We relied upon expert evidence of Dr. Zenz, who put together evidence specifically for the Argentina case, looking at the overall strategy of the CCP in relation to genocide, and specifically looking into removing children from their parents, and the international law provisions which really focus on the removal of important parts of Uyghur society, so intellectuals and teachers and leaders who are being removed from society, and international law has recognized that as being one of the key indicators of genocidal intent. So we're very grateful to have that evidence, and we hope there will be an opportunity to present more of this expert evidence. I know we've got lots of experts in the room who are probably saying, well, look, I've got this kind of evidence which would assist, and it will. So I'll be coming to you and asking for this evidence to put before the courts of Argentina. I think it's very important that we, when we get to that investigation stage, we have as much evidence as possible. So if you've got something, you say, well, you should know about this, or you should put this forward, please do come to me, and I'm very willing to look at that. The criminal submission also goes across all of the crimes against humanity that you can imagine. We all know what's taking place in relation to enslavement, forceful transfer, imprisonment and torture. I don't need to go across all the crimes against humanity, but the evidence is very strong. We've relied on a few emblematic cases as our main kind of cases going forward, just to get to that investigation stage. We have Kelbana Sadiq, who sits here today, who gave a very strong presentation downstairs during lunch. She was a teacher in the camps, and I think she gives, her evidence is very powerful because she was, in some respects, an objective observer of the crimes being committed against the Uyghur people. So her evidence is very important and very unique in that respect. We've got another two witnesses who really cover the range of the offences being committed. But that's not to say we're just going to rely on those three factual witnesses. We really will open it up to look across the spectrum at different witnesses of different crimes in the region. We've also already had an amicus submission from Lord Alton with Ambassador Sam Brownback, Ambassador Kelly Curry, Nuri Turkle and Frank Wolf on behalf of Notre Dame Religious Liberty Initiative, which is a really strong piece of work. I know there are other amicus submissions which might be made to the court as well, which is very welcome. We've been speaking to different states about some state submissions to the courts there as well, setting out the evidence which has been collected by states in relation to genocide and crimes against humanity against the Uyghur people. So it's a way forward. We're very hopeful that an investigation will be opened If the prosecutor and the judge say, no, we're not going to open an investigation, that really gives us an opportunity as well, because then we can go to the Court of Appeal and challenge that determination. In the Rohingya case, you should know the prosecutor decided not to recommend the opening of an investigation, and they went to the Court of Appeal of Buenos Aires and they ordered an investigation to be opened. So whichever way it goes, we've got that opportunity of making these arguments before independent, objective judges, which I think is very important. Thank you.
Thank you, Michael. And so before, if there's any question, I don't know how long time we have. And yeah, and as Michael said, we discussed a number of legal items during the ALMA Legal Summit. And one is just already being undertaken in Canada with the Human Rights Action Group and the Uyghur Rights Advocacy Project. And because refoulement of Uyghurs is a violation of international law, and in particularly is a violation of provision of genocide convention and the Convention Against Torture. And so that there are a number of countries, not only one, Egypt, Uzbekistan, Pakistan, and Tajikistan, Kazakhstan, Afghanistan. They have a history of deporting the Uyghurs back, and those countries do not make any reservation at ICJ. And for that reason, there is a possibility that we can make our case at ICJ. And for that reason, our first request from the Canadian authorities just to register a diplomatic communication with Egypt and Kyrgyzstan is the first step. And then some other steps will follow. And also it is important that we are looking at the volunteer, the countries that can support our initiative. And also we have to get some sort of support from the UN General Assembly, and at least to seek the legal opinion from ICJ about Uyghur genocide. And China cannot veto it, because there is a vote and we need the support from majority of countries, and if we work together, and it should be possible, just the seeking legal opinion from the ICJ is not a political discussion. And so hopefully we can get there. And if there's any question, yeah. Okay.
If I may just comment very briefly, you mentioned Afghanistan, and interestingly, Hazara communities in the UK are looking into bringing, well, of course, a country willing to take Afghanistan before the International Court of Justice, for also under Genocide Convention, for the treatment of the Hazaras in the country, and especially since the fall of Afghanistan in August 2021. So maybe that's an opportunity as well to join forces and then taking Afghanistan for breaches of the Genocide Convention in respect to Uyghurs and in respect to the Hazaras. So that could be also a very powerful joint initiative of communities that are targeted because of their identity.
Thank you. You have a question? Okay, keep it short.
Thank you, everyone, and for all your work in terms of the genocide happening in Uyghur and supporting through legal means. Michael, you mentioned about children's separation from the families, and we have report on Tibet, which again, at UN expert has issued an alarming report last February that nearly 1 million Tibetan children are being separated and sent to colonial boarding school away from their family, age 4 to 5, and similar policies are being implemented in southern Mongolia. And of course, we know about the concentration camp, and of course, this policy of children separating from the family, shutting down all the primary schools, leaving no option, and if basically forcing them to send, they are not allowed to, like, if they will face consequence if they don't send their kids to this boarding school. So in terms of Tibet, nearly 1 million out of 6 million, 1 million Tibetan children are being separated. So collecting all this data, what are the opportunities? Does it also fall under the genocide, as you mentioned, or there can be a larger opportunity in terms of, again, Southern Mongolia and all this region? Thank you.
It can appear as a very powerful indication of genocide, the removal of children from their families, especially if they're taken away and prevented from learning about their culture and their language as well. There are similar policies, of course, in relation to Tibet and Mongolia. But that's something we can definitely have a discussion about in relation to Tibet. But international law, of course, at the moment is quite focused on this idea about removal of children, because we have the ICC warrants against Putin and the Children's Commissioner in Russia for doing just that. So it's a hot topic in international law at the moment.
Would you like to make a comment?
It's just very briefly following up on what Michael said. Indeed, it is crucial to follow the case before the ICC in relation to the abduction of children from Ukraine to Russia, because this is the first of this sort. And of course, also in the case of Ukraine, one of the arguments for genocide is indeed in relation to the abduction of children and transferring them to Russia and stripping of their identity and making sure that they grow up as non-Ukrainians, as Russians. So again, it is crucial to look into the treatment of children across different genocides as a comparison and see how the current responses to similar atrocities are working. And indeed, the case of Ukraine is a great example, and the step taken by the prosecutor at the ICC.
Thank you. And one advice from us, and I spoke a number of times with the Tibetan communities in Canada, and there is a good precedent from the Uyghur genocide that passed in Canada. So Tibetan communities should work with a number of parliamentarians when the parliaments just passed a similar motion in the parliament, and it helps you a lot. Okay, if there's any other questions. Yeah, that's good. And also, just by using the privilege of being a moderator, I would like to mention that we have to use and mobilize whatever not only the legal tool, the administrative tool available. And every country, there is a certain mechanism just to address the issue of forced labor. And for example, in Canada, we used the Canadian Ombudsperson for Responsible Enterprise, and we submitted 14 complaints about 14 companies, and now 8 the companies already being investigated. And it's going to be a strong report about the ties with the Uyghur forced labor. And after that report, and we have a pretty good chance just to push the other government agencies to cancel the import license of those companies in Canada, and also stop the government subsidies. And for that reason, not only the legal means, and we have to also explore some other administrative means in our host countries just to explore these options. Yeah, of course.
Sorry if I missed some part of the panel, but however, thank you. And my question is, Michael represent us. We went to in the Argentina in the universal jurisdiction. We already submission to the Argentina court. I believe around, if maybe you know much better, around 40 countries around the world have a universal jurisdiction. We only know we have one case process on the Argentina. Last couple of weeks ago, I met, in Germany have a universal jurisdiction, I heard. So a couple of weeks ago, 2-3 weeks ago, I talked prosecutor of Germany among this case is a possibility. But she's saying the perpetrator must be this Germany. She answered to me. Maybe she escaped So this is the question. So each country may be different. What is the condition? Maybe different of condition. It will be good if you can answer the question. Thank you.
I'm going to jump in very quickly before Dr. Okchab does. I think what Dr. Okchab is going to say is that under German law, the perpetrator doesn't have to be in the country, but I think they have an unofficial policy that they want. No, she disagrees with me. I've heard that they have an unofficial policy that they require the perpetrator, but universal jurisdiction is permissive, so there's no international preventing all countries from having a really wide universal jurisdiction provision, which is something that I'd encourage the political representatives here to think about. Why are we limiting the use of universal jurisdiction to our own nationals when you've got these obligations on the Genocide Convention to prosecute? And so that's very important for states to go back and for politicians to go back and say, well, why don't we do what Argentina does? Why can't we open up our law so that these people don't get away with genocide, get away with crimes against humanity?
Thank you. So no, the perpetrator does not have to be in Germany in order to trigger the principle of universal jurisdiction. And we've seen that in the case of the Daesh perpetrators, and indeed the first conviction for genocide, that was of an Iraqi individual who was not even in Germany at the time of issuing the arrest warrant, and he was in Greece at the time, and Greece sent him to Germany to stand a trial. And most recently, just a few days ago, Clooney Foundation for Justice filed 3 cases against Russian perpetrators in German courts. And again, they are not in Germany, they are back in Russia at the time. So this is just 2 examples, and there have been proceedings also against Syrian perpetrators who are not in the country. So I think the information that you were provided is wrong, but also I can connect you with a wonderful German lawyer who has been working on the cases of the Yazidi genocide and now is working on the cases of the Russian atrocities in Ukraine.
Okay, yeah, please.
Yes, excuse me. I don't know specifically the case of Germany, but I know that they don't need, because we have the case of the Syrian that they have disappeared in Syria, and the case went to court, and it was a judgment on that. In the case of France, because this is something I can say, in the case of France, we have a very tough restriction, because effectively the perpetrator has to be on a regular basis on the country. This is one of the restrictions. But on the other case, what is very interesting is in the Syrian case, when we look at the César dossier, you know, these thousands of people, the photograph that César has took out of Syria. It's the French government, what they did, and other European government also did, is to go through the picture to find out if there wasn't a binational inside. And in this case, there is no restriction, because if it's a binational, it goes directly under the status of Rome.
I can say in regards to France, France is a brilliant jurisdiction in relation to bringing cases against companies as well. So that's something that the Uyghur community can look at and other communities can look at. It seems to be leading, at least in Europe, in relation to litigation against companies for participation in international crimes. So I'd be very happy to have a chat to you about that.
Obviously, I spent way too much time with Michael, because that's precisely what I wanted to comment. And there's an important case, Lafarge, and that was in the case of, again, Daesh perpetrators working having some kind of agreement with that company, and the company benefiting to some extent from the atrocities. It's a very important case that could be also replicated in relation to companies that benefit from Uyghur labor. And on that note as well, I think in the US, it would be worth exploring whether it is possible to bring proceedings under the Alien Tort Statute. And I wonder whether anyone is already working on it. But again, yet another opportunity, what else to explore?
Actually, this is really good legal brainstorming session. Okay, yeah, let's get the last question and.
Мен Қазақстандан келген.
I came from Kazakhstan.
Қазақстан Қытай білен шекара болып, Қытайдан информацияны азыр Қазақстан арқылы алышқа болады. Қытайдағы ұйғыр милләтіде паспорт жоқ асасан. Қазақлады ма жоқ, амаликін аздап шекара арқылы шығып атыды. Әмді Қазақстанда 50-ке тарта лагер куәгер бар, ұшыққа шыққан, 1000 лагер куәгер бар, іште ұшық шыққан 50 лагер шәйтлері. Лагер шәйтлерінің саламаттығы яқшы емес, лагерде дора ішілеткен, укол саған, әсте сақтылаш қабілетлері жоқ. Әмісінің экономикасы төмен, үй жоқ, ештіміз жоқ.
They have low income and no income and they have financial difficulties.
Қазақстан бұқаралығы берген білен, Қытай тарапының бесімі күштік Қазақстанда ішлей алмайды. İşletmeydi.
Sualınız ne mi?
Hem de sualımız muşu adamlarını çetelge çıksa çıkaralmaydı muşundağı ahval var.
They are unable to move from Kazakhstan.
Ondan keyin kaçıp gelgen adamlar var. Kazakistan'da uçuşqa çıkan 5 var, yani 20 dek var. Uçuşqa çıkmagan. Kaçıp gelgen, hiç kanda dokumenti yok.
Without any documentation, just cross the border, escape.
3 ay, 6 aydan uzartıp koydu. Hiç kanda bir hukuku yok. Bir yerge baramaydı, çetelge çıkamaydı. Kazakistan pukuralığın мәңгі бермейміз деп.
They don't have any identification or they don't have any residence permit in Kazakhstan, and sometimes government issues the 3 months permit temporarily, and so they are unable to move within the Kazakhstan and outside of Kazakhstan.
Kanada vizasını alған Uyghur tuqqanlar бар, ulanıma çıkarmaya atıdı. Ulanı kanda kılış gerek.
Also there are Uyghurs who received a sponsorship and got the visa from Canada, but they are blocked at the airport, unable to move.
Keşip gelgen Uyghur ağayınlar бар, ulanı kanda kılış gerek. Yerukka çıkmagan.
What kind of help
Ешқандай документі жоқ.
Suggest?
Bizni izlep keldi, biz asta-asta azı turib atıdı. Neme qilishni amalini sizlar bilan so'rab atamiz.
It's not very much my area, but I was involved in evacuations of Afghan judges from Afghanistan after the Taliban took over, and we had permission, we were using Greece as a lily pad before we secured visas to other countries. And one key thing that helped us was actually, of course, having wonderful collaboration with Greece to make sure that Greece engaged also with the authorities in Afghanistan. So in this case, it would be crucial for Canada to be fully involved with Kazakhstani authorities or Kazakhstani counterparts, and I think, at least in our case, that's what was key, and that's how we managed to evacuate Afghan judges, female judges, who were on the death list in Afghanistan. But again, this is just from our experience.
That is also the thing. The UN Migration Office, they have office in Kazakhstan, and the Canadian government also contacted with them, and at some point the officials from UN Migration Office contacted those Uyghur families who already received the Canadian visa. The issue is not about the Canada or UN migration. The issue is on the shoulder of Kazakhstan. They are just simply blocking them from exiting from Kazakhstan. That is the issue, because there is a Chinese pressure, as you mentioned. Thank you, and our time is up, and I hope we will continue to have this legal discussion, and the next time the more specific cases maybe. And thank you for listening, and sorry for if there's any The shortcoming in my moderating, this is my first time. Okay, thank you.